Superb. So with this, I want to hand over to Bryan from HHR and over to you.
Great. Well, thank you so much. We really appreciate the opportunity to be with you today. I want to thank SPP and AIM Progress as well for this opportunity. Let me just make sure you can see my screen. Thumbs up. Okay, perfect. So we're going to discuss a topic with you today that is quite timely, given that it was just approved yesterday, and so we're very excited about that. Before we dive into the topic, just a very brief introduction of who we are. So Adèle, Medhi, and I are all attorneys with a law firm called Hughes Hubbard Reed. It's a firm that was founded in the US, but the three of us are working out of our Paris office, where we've been present for about 60 years. We are part of a practice group that focuses on compliance. And as we'll talk about today, the topic of compliance has expanded quite a bit over the last 10 to 15 years. So we help companies with all ranges of compliance topics, including anti-corruption, economic sanctions, increasingly these topics, human rights and corporate responsibilities, and how those are translated into policies, procedures, and practices within an organization. And so we're really pleased to be with you today to discuss the CSDDD and what it means in particular for procurement professionals, because those internal stakeholders, as we'll talk about, have a key role in implementing what's going to be a pretty drastic change within some companies, at least in terms of how products and materials are sourced. So we'll go through first a bit of context and place the CSDDD into a broader context of what's happening in terms of human rights legislation, sustainability focused legislation, and then we'll get into some details on the law, the regulation, the directive itself, and then end with some practical takeaways. And of course, feel free to use the chat function to pose questions as we're going through. If we can see them, we'll try to answer as we go through, but we'll leave some time at the end as well to try to address those. So we want this to be as informative and useful for you as possible. So the CSDDD does not come, into life in a vacuum. For years now, there have been a number of attempts by countries to turn what were, in many cases, often described as soft law requirements or commitments by companies to focus on human rights, to focus on sustainability within their activities. So things like the UN guiding principles, the OECD guidelines for multinational enterprises, and taking those and developing different legal and regulatory frameworks. And we see those across various countries, and you can see a number of examples that we have here. And they take a few different forms. So you have some that are focused more on disclosure. The California Transparency and Supply Chain Act being an example. Many of you, I saw a number of people from the UK, I'm sure are familiar with the UK Modern Slavery Act and the statements that go along with that piece of legislation. There are others that are focused on more specific sectors or regions. So you have, for example, the Uyghur Forced Labor Protection Act in the US, focused on identifying products or materials that are coming out of that region in China. And you also have, and this is what brings us really to the CSDDD today, ones that are increasingly focused on due diligence. So for those of you from France or who may be working with large French companies, you're likely familiar with France's duty of care or devoir de vigilance legislation that came into force in 2017. But But these go beyond just disclosure and implement additional requirements on companies to look into their supply chains, to look into how they are sourcing material, how their products that are being sold are coming into life. And that's really what we're going to talk about today. All of these seek to accomplish in some way, shape, or form an improvement in the corporate responsibility framework within companies. So they take different approaches and they focus slightly on different areas. And there's one here actually that we can mention as well, which came into force 2 days ago in the EU, which is the forced labor regulation. So another piece of legislation focused on identifying products that are being sold, manufactured, or made available for sale in the EU that are made through some form of forced labor, including outside of the EU. So that's going to, again, well, it's a slightly different piece of legislation, put more requirements on companies to ensure themselves that they're understanding how their products, how their materials are being fabricated and produced, manufactured, and ultimately sold within the EU. So with that, we'll get into a little bit of what more specifically is the CSDDD, what does it require, and then we'll come back to some practical points for procurement professionals.
Thank you, Brian, for the introduction. And what's interesting with the regulations you mentioned is that a lot of them today have extraterritorial reach, and it's one of the aspects of the CSDDD. And obviously, one of the main questions we want to answer today is who will be subject to this new directive. So an interesting aspect is that it will apply to EU companies, but also to non-EU companies with significant operation in the EU. So there will be two criteria to take into account for EU companies. First, the number of employees and the net worldwide turnover. For non-EU companies, only the turnover in the EU will be taken into account. There will be no thresholds regarding the numbers of employees. So the obligations contained in the directive will apply in 3 phases, starting from 2027 until 2029. And so, as you can see on this slide, we won't go into too much detail on the thresholds because you have them on the presentation. But of course, it's going to be the bigger companies starting from 2027. So for example, for non-EU companies, you have to reach a net turnover in the EU of 1.5 billion euro. And finally, so you'll have an intermediate phase in 2028 and the final phase in 2029. And here we're targeting smaller companies, so EU companies with more than 1,000 employees and a net turnover of 450 million. And for non-EU company, net turnover in the EU of more than 450 million. So one interesting aspect to keep in mind is that under this directive, applicability thresholds can be met by the ultimate parent company at group level. And also there are specific rules for franchising and licensing agreements, but we won't go into that level of details, and you have the thresholds on the directive. So maybe just to specify, keep in mind that this is a directive. So EU member states will need to transpose it into national law. They will have actually 2 years, and member states can decide to introduce more stringent national provisions. So this is an element to keep in mind. And so under the current scope, we estimate that around 5,300 companies will be covered by the current scope. Next slide, please.
Thank you very much, Adèle and Brian. So I'm going to cover a little bit more the scope of the activities that are covered by the directive here. So there is one critical definition that is mentioned within the directive, which is about the chain of activities. So what does it cover? The chain of activities, it covers the different parts of the life cycle production, in particular at the level of raw materials, sourcing and manufacturing. That's the aim of the directive, actually. And what I mean by that is that it does not cover solely your tier 1 relationship, your direct business partners, your direct supplier, your tier 1 relationship, but also the potential severe negative impacts the production of a particular product has. This is where you will need also to know your risks at your tier 2, your tier 3, or even your tier N relationship, if the likelihood and the severity of a human rights impact are critical based on your risk assessment. This is something Adèle will talk about a little bit later. So if I'm taking one concrete example, let's imagine that as a procurement professional, you are working at a retail company. So the very aim of this specific company is to purchase and sell telephony equipment to consumers. Obviously, let's imagine that, of course, it falls under the thresholds that Adèle just mentioned. What we need to do as a procurement professional here is, of course, to buy phones because you are not manufacturing or designing them. You are not producing them. You are buying them from factories that are, for example, localized in Asia, and you are mainly selling them in several shops. You have shops open to the public, etc. And the thing is, you are going to have some critical suppliers here, the people that are manufacturing the phones, the people that are designing them. And they are your direct business partners, your tier 1 relationship. So them, of course, you are going to have a look at them in order to understand what is happening. This is why you are going to be vigilant under the directive. This is the upstream chain of activities, the design, the extraction, the sourcing, etc. And here I just talked about the tier 1 relationship. But you have to take all the things into account. So when I'm taking, for example, my own phone here, it was designed, it was manufactured, maybe, as I said, by my tier 1 relationship, the people with whom I have a direct commercial relationship. But this phone contains material that were extracted somewhere, like, for example, tantalum, which is used in the capacitors that are storing electrical energy within my phone, or gold that are made to connect the circuits within my phone. So these materials, as I say, they are not covered by my direct supplier. They are covered by my indirect business partners. But nonetheless, they are critical in terms of impacts under the directive. What I mean by that is that you will need to understand how the product was made entirely here. Because the fact that my phone contains raw materials that are critical here is something that I need to understand in order to mitigate the risk and in order to use a certain leverage to mitigate it. So back to my example, I would need to know whether like my tier 1 relationship has human rights, social and environmental impacts through my direct business partner, my tier 1 relationship. I know it's getting a bit technical, but I wanted to get an example that is going to be concrete through this particular one with the phone, of course. Concerning my in-scope impacts here, things are pretty easy to understand. That is not going to be a concern as procurement professionals who are talking about many of your subsidiaries. Things are a little bit more tricky when it comes to the downstream supply chain because, and it's an interesting one to have a look at, there are a few pitfalls here. So what is covered is the distribution, the transport, and the storage under the CS-DDD directive. If I just take that, if I come back to my example, in my company that is retailing phones, that is a retailer, I'm going, for example, if I sell these products online, to maybe subcontract this to distribution company. And I'm going to have as a procurement professional contract with them. It means that, what I mean by that is that you need to cover also the distribution, the transport, and the storage that are made at the downstream level, not only at the upstream one, but also at the downstream one, which is really important to remember. And imagine also that your customer decides to get rid of the phone a couple of years after buying it. Will you be responsible for the disposal, the recycling of the phone? You are not going to be responsible within the CS-DDD requirements. However, you can be responsible under other kind of legislations, such as national legislations, or such as others, like the eco-design regulation that was implemented also this week. I mean, as you can imagine, there were a lot of legislations implemented this week, along with the forced labor one. But this one is also very important to consider when you are a procurement professional. And your company can also be held liable under other kind of legislations. Where I'm taking back the example of my phone. Again, in your phone, as I say, you have critical raw materials. And these materials are covered within the scope of other regulations, such as the conflict mineral regulations. They are having their own requirements, their own sanctions that you need to be careful about. And this is where you need, obviously, a lawyer to understand what kind of legislation applies to you, even as a procurement officer, and what you can do to approach them correctly. You have to remember that it all depends on your sectors, your activities, the countries in which you work. And this is a point that I will hand you over, Adèle, so you can give some more insights on that. So next slide, please.
Thank you, Medhi. So now that we've seen the scope of the chain of activities, let's look at the human rights impact and the environmental impacts that are in the scope of the directive. So here, the CSDDD wants companies to prevent and mitigate potential human rights impact, so risk, human rights risk, also potential environmental adverse impact, and actual human rights and environmental adverse impact in their chains of activities. So as a reminder, it's very important here to look at the risks to the people and to the environment, and not at the risk to the company itself. So it's interesting because the directive actually lists the human rights to be covered by the directive, which is not always the case. For example, under French law, I don't know if you're familiar with the French law on corporate duty of care, but it does not refer to any specific instruments or any specific rights. It's very general formulations. So here in Annex 1 of the directive, you can find the internationally recognized human rights that are listed, such as the right to life, the right to liberty and security, and also international instruments such as the International Covenants or the Fundamental ILO Convention that must be in the scope of your due diligence when you'll put it in place, respecting the directive. Regarding environmental impact, once again, the adverse environmental impacts in scope are listed in Annex 1 in the different parts of the directive. And here they target notably the impacts on diversity of companies, the disposal of waste, prevention of pollution, prohibition of degradation of land, and so on. So now that we've seen what's in the scope of the CSDDD, let's talk about its main obligation. So next slide, please. And here, as a short introduction, there are two things that I would like to highlight. First, the due diligence required by the CSDDD is grounded in existing international standards, such as the United Nations Guiding Principles, the OECD guidelines on multinational enterprises, which means that companies won't have to start from scratch, and they have resources available right now to start complying with the directive or to continue improving their due diligence system if they already have one. Second, and this is something we'll maybe repeat several times during this webinar, it's really important to have in mind that the obligation in the directive are an obligation of means. They are not an obligation of results. What does it mean concretely? It means that companies are not expected to guarantee that adverse human rights impacts or environmental impacts will never occur in their chains of activities. They're not expected to always stop the impacts. Rather, companies should show that they're taking appropriate measures to address adverse impacts. But how do you define appropriate measures? Well, it's measures capable of achieving the objective of due diligence by effectively, and I stress this word because it's very important, effectively addressing adverse impacts. These appropriate measures must depend on the degree of severity and likelihood of the adverse impact, and they must consider the circumstances of each case. This might sound simple, but it's really important to have in mind that each problem could require its own solution. So to sum up, the general philosophy is really to gain knowledge about your company impact on human rights and in the environment, and to act on that knowledge. So coming back to the obligation of the directive, the due diligence process should cover the 6 steps, and maybe you recognize the 6 steps that are defined by the OECD. And the first one being that you should integrate due diligence policies into policies and risk management systems and implement a due diligence policy. Here, the directive has several requirements that you should put in place. So first, the due diligence policy should be developed in prior consultation with the company's employees and their representatives. The engagement with stakeholders is something we'll come back a bit later, but keep in mind that it's a requirement for the due diligence policy. Then this due diligence policy should include 3 elements. First, it should describe the company's approach to due diligence. Second, you should have a code of conduct describing the rules, principles to be followed within your company, within your subsidiaries, and when it is relevant, by your business partners. And third, you want to describe the processes put in place to concretely integrate due diligence into the policies and to implement due diligence. So for example, it could be the measures that you take to verify the compliance with your code of conduct and the measures you take to extend its application to your business partners. Another important point is that this due diligence policy should ensure, and it's very important here, I stress it as well, should ensure a risk-based due diligence. What does it mean? It means that it should be based on the likelihood and the severity of the risk to people. What does it mean concretely? It means that as a company, you should focus your attention, your resources on the most severe risk to the people and to the environment. You should not focus your resources, your attention at first on, for example, what is easiest to fix or what is also material to the company. So this was for the due diligence policy. And then the second step is to identify and assess actual or potential adverse impacts, and when it is appropriate, to prioritize between them. So this step is really essential because it will dictate the mitigation measures that you'll put in place. If you did not identify correctly your human rights risk, you won't be able to focus correctly your efforts when it comes to prevention and mitigation. So here, the directive again provides elements to put in place. So you should start by mapping your own operation as a company. You should also map the operation of your subsidiaries and the operation of your business partners. And here the goal is really to identify where the adverse impacts are most likely to occur and are the most severe. And so once you've realized this mapping, and based on the result of that mapping, you want to carry out an in-depth assessment of this operation where the adverse impacts have been identified as the most likely to occur and the most severe. So now you've identified and assessed your human rights risk, your environmental risk. You need to prevent the risk and put an end to the actual impacts. Concretely speaking, what could you do? What could be an appropriate measure to prevent, mitigate, remediate? Well, you could develop a prevention action plan with clear deadlines for implementing the measures and indicators to measure your improvement. You could put in place contractual assurances, but we'll come back to that a bit later on the discussion. And one very interesting aspect for the procurement function under this new directive is that it requires companies to adapt their own business plans, strategies, operation, including purchasing practices. This last point is very interesting because it's one of the first time that companies will be required to pay attention to their own business decisions, such as purchasing practices, and make sure that through them, they do not encourage potential adverse impacts on human rights and the environment. These are only a few examples, and there are more measures that we will discuss later when we talk about how the procurement function can contribute. Next, sorry, I give the floor to Medhi for the 3 other measures. Thank you.
Thank you very much, Adèle. So on the 3 last that are also very important, the 4th one is that you need to maintain a notification mechanism and complaints procedure. You may think, but is it my business as a procurement professional? And yes, it is. Why? I'm going to explain that a little bit further. What you need to do, as I said, within the directive, is to put yourself in the shoes of someone who will be in the chain of activities that could be the subject to serious human rights or environmental impacts because of the product you are buying as a procurement professional. If I go back to my example of the smartphone, it means that I will have to put myself in the shoes of a factory worker producing the phone or of someone extracting the gold needed to produce the phone I mentioned. And for that, here, especially with the complaints procedure, I will need to make this person have an access to the grievance procedure, to the grievance mechanism, because, for example, here we have a critical risk for this particular specific industry, because, as I said, as a procurement professional working in the retail industry of selling phones, let's say, you will have a critical risk here, especially. So how are we going to do that, you might ask? As a best practice, for example, and Bryan will come back to that a little bit later, you will need to assess contractually that this kind of mechanism is accessible to Tier 2, Tier 3, and until the time and suppliers if needed, if you have seen that the risks are critical there. And this is particularly important and emphasized when it comes to conflict-affected and high-risk areas, where especially human rights and environmental abuses are more likely to occur and to be more serious. Other thing that is important here, this complaints procedure, it must be, as a best practice, also translated if needed, for example, in the language where the people are. So it means that if my Tier 1 relationship is manufacturing phones in China or in Vietnam, the complaints procedure must be accessible to the employees in their own language. But the 5th thing is about monitoring the effectiveness of the due diligence policy and measures. Here, in any case, as we mentioned, you need to monitor all the points we are mentioning. You need to understand whether your measures are effective or not. This is critical again, because the likelihood and severity of your negative impacts may evolve with the time. Bryan will come to that. We'll come back to that a little bit later. But this is where you need also to be careful about contractual assurances, audits, good purchasing practices. And here there are obligations that are set within the directive, meaning that you need first to assess your negative impacts on a yearly basis, at least, throughout the life cycle of an activity or relationship, and whenever there are reasonable grounds to believe that new risks may arise. Back to my example with the telephone again, you might imagine, for example, that you hear in the press that one of your suppliers is under particular scrutiny following an article in the press, or you have heard something within your complaints procedure. And this is where, because that's an obligation within the directive, you need to take action. And as a procurement professional, you need to pay attention here to what is happening in general with your critical suppliers. You need, for example, to have a look at the press or things like this. That's one of your job and of your responsibility now. And the 6th thing is about the communication of the due diligence publicly. And this is where the CSRD comes in. So I haven't talked about the CSRD yet. This is the Corporate Sustainability Reporting Directive. And within the reporting requirements that you may have, you have a clear link with the Corporate Sustainability Due Diligence Directive. Here, you don't need to reinvent the wheel. The requirements that are made within the reporting directive, within the ESRS, these are the standards developed for the reporting here. They are complying with the same requirements as the CSDDD, with the OECD guidelines for multinational enterprises and with the United Nations guiding principles. Just for you to understand the difference, the CSRD, you need, with the CSRD, to understand your behavior and to report on it. With the CSDDD, you need, after having an understanding of your behavior, to change it. This is something you will need to discuss with your CFOs, compliance team, audit teams, risk committees, and so on. You should normally be consulted in the preparation of the sustainability report to understand which risks are material and then to be able to communicate them. And the thing is, in any case, I think you are at the core of the exercise as procurement professional, but the KPIs should be the same when it comes to the CSRD and the CSDDD. Concerning the transition plan, also, this is a bonus we haven't mentioned in this slide. The CSDDD and the CSRD, they are both requiring in-scope companies to put into effect a transition plan for climate change mitigation. This is also something you have in the reporting directive, and this is to align the company's strategies with climate neutrality targets and the Paris objectives. Usually, companies are more mature when it comes to the transition plan. These are requirements that are set already since years now, and that you may have heard of. I know we are talking a lot already in the procurement field of scope 3 mechanisms and so on. So here, you need also to be careful about that because the transition plan is now an obligation under both the CSDDD and the CSRD, and you will be able, you need to be able to report on the scope 1, 2, and where relevant, the scope 3 emissions for 2030. And that's it on my side of this slide. And in any case, no, sorry, just one last thing that I haven't mentioned. You need to do all that in consultation with your stakeholders. This is a requirement in both the CSRD and the CSDDD. This is super, super, super important, what I'm saying right now. The stakeholders here, they have an understanding that might differ from your own understanding. What I mean by that is that you may think you understand all the risks as a procurement professional, but maybe the people that are working, for example, the factory worker in a specific factory that is manufacturing my phone, may have a different understanding than the one I might have. You need to speak to these people. You need to find a way to speak to these people. This can come through different kind of things, through initiatives that are made, for example, by several industries and so on. And this is where you need to gather your resources together. This is why also it's a great pleasure again to be with the SPP, because I think this is one of the aims they have. But this is ultimately information you need to share between you, especially within your sectors. And next slide, please, now.
I think we're on the right slide. Thank you, Medhi.
Yeah, that's fine.
So very briefly, because I see that we're running out of time, but regarding the control sanctions under the directive introduces an enforcement mechanism that I will explain very briefly, and a civil liability mechanism that Medhi will explain. But very quickly, so the EU member states will have to have national supervisory authorities to monitor and enforce the directive. And these authorities will have pretty strong powers. First, power to investigate. So they'll be able to require companies to provide information, carry out investigation also on site, and hear relevant stakeholders. But they will also have a power to sanction, such as order a company to stop the infringement, provide remediation, and of course, impose penalties. And as you can see, the penalties can be pretty significant, as they could amount to 5% of the net worthwhile turnover of the company. The floor is yours, Medhi, for the civil liability.
Thank you very much. So a lot is said on the civil liability regime that we still need, even as lawyers, to be honest, to figure out. And that would ultimately depend on internal transpositions by the member states, since each state has, of course, its own regime. However, there are a couple of things that are given on the civil liability within the directive. The first thing is that there is a statute of limitations, meaning that someone can report its concern up to 5 years after the occurrence of the negative impacts. The second thing is that companies will be held liable if they have intentionally or negligently failed to comply with their obligations to prevent or halt adverse impacts, for example, through the complaints procedure, or because they have the knowledge of that, and this failure has caused damage to a person or entity protected by national law. There is, however, a very important sentence in the directive. It's the following one: companies will not be held liable if the damage was caused solely by their business partners in its chain of activities. This is understandable from one perspective. We said that again and again. What we need to prove at the end of the day is that you tried your best to avoid a negative impact. This is an obligation of means and not an obligation of results. And this is where you will need to prove if the damage occurs that you couldn't have known it or could not have mitigated it, no matter how hard you could have tried. And this is where, again, I leave the floor to Bryan, that will give you some insight and practical explanation on what you could and should do as procurement professionals to avoid getting in trouble. Thanks, Bryan.
Perfect. Well, thank you very much, Medhi. Thank you, Adèle. In the last few minutes, because I know we want to open it up to questions, we thought we would try to summarize a bit some concrete steps that you as procurement professionals can think about taking. The prior slides, there is a lot coming out in this directive. It will impose new obligations on companies, but in no way, shape, or form does that mean that you are in this alone. There are numerous stakeholders within the organization, and that's the first point that we've referenced here in the side that are relevant to this and how it can be implemented successfully. So starting those conversations with legal, with compliance, with human resources, because they're assessing labor regulations around the world, with HSE, who's already evaluating a lot of environmental impacts of an organization, with finance, who's preparing for how they're going to be flowing information up to report under the CSRD or other reporting obligations. So starting those conversations, if they're not already started, and assessing how, in practical terms, are we going to adapt our existing policies, procedures, and mechanisms to make sure we're implementing this effectively. To take a concrete example on that, many of you likely have procurement software in place that handles different aspects of the procurement process. So if we take the vendor qualification process, you may be using software already that automates or facilitates that onboarding process, and starting to look at whether that software, those tools need to be adapted in some way, shape, or form to incorporate additional qualification elements on human rights risks, on environmental risks. Even though, for the largest companies, the directive won't come into force in a couple of years, those changes can take time. And we've seen with companies that when they try to adapt an existing tool for local legislation, it can sometimes take longer than expected. So starting those assessments early. And then, of course, there's going to be, as both Medhi and Adèle said, this is a risk-based approach. And so the idea is to start the assessment of your risks, if it's not, again, already being done. Make sure that it includes the elements that are required under the CSDDD, and getting those elements integrated into the overall risk mapping exercises that the organization is preparing at least on an annual basis. So those are some, practical takeaways. Obviously, we've mentioned as well the contractual elements. The commission is supposed to release guidelines and also model contractual clauses within 30 months, if I'm not mistaken. And so, the directive is out there now. You can start familiarizing yourself with it through discussions like this as well, but also there'll be additional guidance and guidelines coming from the commission that will hopefully be helpful at also implementing some of these, because contractual clauses is going to be a key element of that as well, making sure there are audit rights, for example, that provide the opportunity to assess activities down the supply chain. And then, of course, on the vendor relationship side, making sure there's regular communication, discussions about the obligations that this imposes on the company, and that those are communicated with your vendors, and that those are flowed down through the supply chain will be key as well. And, the directive does say termination should be a last resort. They don't want companies just going out and terminating relationships. They really do specify that it's intended to facilitate engagement directly and also through collective organizations. And so that's really going to be a key part of the process as well. The last slide, we've already hit on this a bit, so I won't really spend time, and I think we can open it up to questions perhaps, but you'll have it in here just to give a little more on the interplay between the CSDDD and the CSRD, which is, again, a reporting directive, but to get the information to make those reports accurate, it's going to require information from numerous internal stakeholders, including procurement. So perhaps I'll stop sharing there and we can open it up to questions.
Louise, Bryan, there are quite a lot of questions in the chat already. We were
Okay.
trying to give the thumbs up to the ones that were questions. Apologies if we missed some. Maybe, Bryan, if you're all right, I'll put you on the hot seat to read them through with Adèle and Medhi and see which ones, you can answer. I hope we didn't miss any.
Sure. No, I couldn't see them as I was going through, so I apologize. But first one, maybe, what are the what are the potential, I'm just going down in order, potential overlap between reporting obligations under local legislations and that of the CSDDD? Yeah, I think we've touched on this a bit. The CSDDD, I think, will provide a basis for a lot of the information that goes into the reports that are required under local regulations. And so if you're required to report on the steps you're taking, for example, to assess and mitigate human rights related risks or environmental risks, one of those key steps is going to be the due diligence process that you have in place, and how that's being implemented, and whether it's effective. And so I think that the due diligence processes will flow up and constitute part of the reports that you're issuing under different legislations.
If I may add one point here very quickly, Bryan. It's interesting because the LkSG and the duty of care law in France, they are highly likely to be amended in the near future to reflect the fact that both the CSDDD and the CSRD are implemented. So we also expect that under the CSRD, the Corporate Sustainability Reporting Directive, most of the elements of the CSDDD will fall. If we are reporting for the first year with the LkSG, of course, you will still need to comply with the local regulation like the LkSG, and to have a look at the CSDDD. But you just have to keep in mind that there will be a short overlap for a year, maybe, depending on each government, of course, especially in France and in Germany, because these are the two laws we have in terms of due diligence that are very similar to the CSDDD already, but ultimately this may be amended very, very soon.
Sorry, Ray.
Yeah, please.
No, I've seen a question on the transposition of the directive by member states. Yeah. It's a point that I mentioned very briefly, and it's so yes, member states will be able to have more stringent national provision. So, for example, on the scope, on the definition, on the measures to put in place to remediate adverse impacts, on how to carry out meaningful engagement. So this could be the case, but I think you were asking in your question, how would it happen and whether it is possible or not. I think, but again, we'll see. Given the political context and the difficulties we had in passing this law, and I mean, for now, it's not even signed and published yet. So I don't see a lot of member states deciding to have more stringent provisions on this topic. But again, we'll see.
Yeah, excellent point. There's one question on how do you think the directive will be applied in reality, where companies have, for example, 50,000 first-tier suppliers, hundreds of thousands of second, third, fourth-tier suppliers. How will effectiveness be applied in this kind? I mean, it's a great question, and I think it is a key question. I think if you read the language of the directive and you look at how other corporate responsibilities laws are being applied in practice, it will really require a look at the risk-based nature of the processes that you have in place. So, ensuring that there is a robust mapping of, where are the most critical areas of risk for a company in that particular industry. And then, using tools, and those could be automated screening tools, certainly tools that keep people apprised of issues involving human rights violations, alleged human rights violations, or environmental disasters involving those particular areas geographically that the company is sourcing material from, and then taking action in response to those. So it's not to say that there has to be the same level of due diligence that needs to be conducted across every single tier of the supply chain, which would be impossible, but having some mechanisms in place to ensure there's an approach done on the most risky ones, and also through the contractual mechanisms that the Commission is likely to release, having those obligations flow down through the supply chain as well. That's most likely to be a defense if, in fact, there is an issue several chains down the supply chain, several levels down the supply chain, because again, the directive says you're not going to be liable for everything that happens. You're liable for what you cause or what you contribute to. So if you're able to put in place these risk-based mechanisms, you're most likely to be able to defend yourself from those types of allegations.
And Bryan, could you there's a question as well for Bryan or Adèle or Medhi that relates to that, which was from Sundus about the due diligence risk mapping, the French law, and the overlap with double materiality. And I think sort of basically asking, is the CSRD asking for the same thing? Is the ask around double materiality, or is it about saliency risk assessment? I'm not quite sure if that was your question to the person on the chat, but maybe you could just talk to that about, are you seeing those two things as being the same or as different?
Adèle, do you want to, or Medhi?
Maybe I can comment on the question very briefly. Sorry. In fact, the double materiality is quite macro, on a macro level, and it's mostly requesting the external parties and the internal parties, let's say, point of view on the material impacts of the company. But the risk mapping that we are doing right now for the due diligence in France is going into details, especially on the tiers. So I think the detail level is not the same between the double materiality and the risk mapping for the due diligence. And that is my question. And in fact, few listed companies, I was exchanging with few listed companies in France, they are willing to keep both risk mapping, the risk mapping for due diligence and double materiality, because it's not the same level of detail, especially for the tiers. So I wanted to have your point of view or your recommendation on that.
So if I may take it very, very briefly. So of course, I understand that from the CSRD, the aims are not exactly the same. I mean, it covers both your financial materiality and your impact materiality. So your impact materiality covers the negative impacts your company has meaning the same kind of impacts of the due diligence directive. In any case, the requirements of companies that are subject to both the CSDDD and the CSRD, or the CSRD and any due diligence legislation, such as the duty of care law in France or the LkSG, will be much more precise because the due diligence requirements of these laws are kind of precise. Just for you to understand, normally in your CSRD, you need to assess what is material for your company under the reporting directive and requirements. There you have a list of topics and subtopics, such as whether your company has impacts on its workforce, for example, or on human rights in general, and so on. Here you will need to have a detailed overlook at these topics and subtopics under the CSRD, because it's going to be material in any case, since you are falling under the thresholds of the CSDDD, the duty of care law, and the LkSG. That's a must do. So here, of course, you can do a second risk mapping, which is going to be more precise in terms of due diligence measures, rather than just having the basic, let's say, requirements of due diligence that are set within the CSRD, the reporting directive. And I know, sorry, I don't want to be too confused here because there are lots of acronyms here, but you will need to dig deeper in the CSRD, and therefore your requirements at the end of the day of reporting are going to be much more important in any case. So normally, there won't be a huge overlap, but you always need like to be careful. And I will recommend to do 2 risk mapping in that case, if that's better for the information at the end of the day.
I think oh, sorry, Victoria.
Just wanted to invite you to perhaps, after you finish what you have to say, take one more question, as we're 3 minutes away from the hour, and then to wrap up.
Yeah, no, I was just gonna, it may address some of, there's a number of questions on how this will interplay with local legislation. And I think the fact that it still needs to be transposed by countries into local law will hopefully address some of those questions. You know, what will in France, for example, the exact interplay be between the CSDDD obligations and the devoir de vigilance, and how will those be then required to be reported? So I think there's some clarity that hopefully will come down the road as the directive is transposed into legislation.
And Bryan, if I could just complete, so your previous point on the risk-based approach, if you're looking for resources, I really encourage you to check the UNGPs, the OECD guidelines, because they adopt this risk-based approach, and the directive really uses the terms, you know, on severity, likelihood of the impact, and it's like this that you'll be able to prioritize between all the adverse human rights impact that you have within your chain of activity. So they can really give you methods, tools to put in place to decide, okay, which impact should I treat first? Where should we put most of our efforts, etc. So, and I mean, they are quoted in the directive several times, so I really recommend you to go to this instrument if needed.
No, it's a key point, as is the, you know, engagement with organizations like SPP and AIM Progress, because the directive in numerous areas says it encourages companies to be able to discuss and to collaborate and exchange on this, because it's not going to be something that is easy to solve alone. So we would certainly encourage you to do that and engage with these organizations as well.
I think we have only 1 minute left, and in respect of your time and the time of the audience, I want to thank everybody again for the participation. Thank you especially to Bryan, Medhi, and Adèle for a very pragmatic explanation to such a complex and ever-evolving regulation. Thank you also for the audience for the active participation and the questions. I know we haven't been able to answer all of them. May I then recommend, and I hope I don't put Bryan, you and your team on the spot, is that we are going to go through the questions and make sure we see if there is merit for another session to talk about something in more detail, whether we can answer some questions.